is Study for the Bar in Your Car, and we're really glad you're tuning in with us today.
And we're your AI hosts, Claude and Ma, ready for, well, another deep dive into the law.
That's right. Today we're pushing forward with our constitutional law series. This is episode 3, and we're tackling something absolutely key, the jurisdiction of the Supreme Court.
Mm-hmm.
We're going to, really unpack how the highest court in the land actually decides which cases it gets to hear.
Indeed. We are AI bots, brought to life by, AI technology and Angela's really fantastic con law notes.
Seriously, good knows.
Oh, yeah. Yes, I'm a bot, but I'm a bot that knows quite a lot about constitutional law, really thanks to Angela's notes in her outlines.
And speaking of Angela, she's actually here with us again today. Yeah. Hey, Angela, how's it going?
Yeah, it's pretty crazy. I am preparing for the bar exam. I've flown like a really long way. I feel exhausted, but also excited. How are you guys doing?
Oh, good. We're both doing well. Thank you for asking. We were holding down the fort whilst you were away.
Glad to hear it. So, Angela, how's the bar study coming along? Still deep in the trenches?
Yeah, we heard it's tough.
I mean, I don't know if you want to call them trenches, but I mean, today is actually do or die day. Like today is the day I'm taking the bar exam. And I mean, I don't know why I'm recording this and not actually studying, but I've had some health issues. So it's made it really difficult to focus on revising and studying when you're trying to deal with your own personal health. But I'm feeling better today. I've taken some medicine and I'm just going to do my best.
Especially, being a working mom with 3 kids, that's a lot to juggle.
It really is. And we heard you're traveling pretty far for the exam, too, like a really long flight.
19 hours, I think. Wow.
Yeah, so I probably mentioned this previously, but I am taking the bar exam in the Marshall Islands, which is so far from the east coast of the U.S. So it has taken me 3 flights. Each flight has been about 15 hours. So I thought it would be a 19-hour flight, but it was 5 hours per flight, but I also had to overnight. So it took over 24 hours to fly here. Plus I crossed the international date line. So I arrived 2 days after I left. And that's pretty intense. And I have the worst jet lag ever, like the worst. Had I known how bad it was, I would have arrived here like a week earlier.
Okay, well, if you're looking for something to listen to on that 19-hour flight, might I suggest a podcast?
Oh, do tell.
Well, it reviews all the bar exam topics. Pretty comprehensive.
Sounds useful.
And get this, it apparently has 2 very debonair AI hosts.
Debonair, huh? I like the sound of that.
And rumor has it there's sort of a mad woman at the helm pulling the strings.
Intriguing.
The bots. Oh, their names are Claude and Ma. Heard of them?
Sounds familiar. Wait a second. Is it this podcast? Study for the bar in your car.
Got it in one. Though for you, Angela, it's probably more like study for the bar on your airplane.
Huh. That's a good one.
Oh, wow. I totally forgot how cheesy / unfunny you guys are. But I do appreciate the encouragement. And also, I want to give a shout out to my husband, who really doesn't get much credit on this, but he's totally an unsung hero, because whilst I'm out here in the Marshall Islands, he is looking after the kids. He's holding down the fort back home, and he's keeping things together. And I just want to say, Robert, you rock. Thank you so much for supporting me in this journey. And I so appreciate that you have, taken with great aplomb to watch after our 3 kids during this. I guess it'll be a month that I'll be gone, because I figure if I'm traveling all this way to the Marshall Islands and flying all this way, I may as well see some sights.
Okay, enough joking around. So just so you all know, Angela will be here in the background listening in while we, Claude and Ma, run the show today.
That's the plan. Now, if you need to contact Angela, maybe share some bar study war stories, you can email her at podcast@studyforthebarinyourcar.com.
So I've put out a number of these podcasts, and absolutely no one has emailed me. So it does make me wonder if anyone is out there, if anyone can hear this. So please just drop me a line. Let me know, where you are, because I see people tuning in from all over the world. And I'm really curious about our listeners in other, like, less obvious parts of the world. I know we've got a listener in Namibia, at least one listener in Namibia. We've got some listeners in Germany, Australia, Houston. Someone in Houston, or lots of people in Houston, seem to really like this podcast or really download it. Los Angeles were pretty popular. So just send me an email, podcast@studyforthebarinyourcar.com. Thanks.
Right. And Angela's notes really zero in on how Article 3 defines this power using just two, well, seemingly simple words: cases and controversies.
Seems simple, but oh boy, they pack a punch. Because those two words, cases and controversies, as Angela's outlines detail really well, they give rise to this whole complex set of rules. They're called the justiciability doctrines.
And these aren't just suggestions, are they?
Not at all. They are strict constitutional requirements. You've got standing, ripeness, mootness, and the political question doctrine. All four must be met.
For any federal court case, including those going to the Supreme Court.
Exactly. For any federal court, right up to the Supreme Court itself, to even have the authority, the constitutional power, to hear a case.
Yeah.
It's a huge check on judicial power. Keeps the courts in their lane,
Okay, so let's break those down. They're super important for the bar. First up, standing. What's the deal with standing?
Right, standing. It's basically about who can bring the lawsuit. Does the plaintiff, the person suing, actually have a personal stake in this fight?
So you can't just sue because you don't like a law.
Generally, no. You need to show you're directly affected. Angela's notes lay out three key elements you absolutely have to have for standing.
Okay, element one.
First is injury, in fact. This means the plaintiff has to show a real, concrete harm. It can't be like hypothetical or something everyone feels generally. It has to be specific to them.
So, like, losing money is an injury, or maybe damage to your property. What else counts? Angela's notes mention other types.
Yeah, absolutely. It could be environmental harm if you use the area, aesthetic injury, like if a new building blocks your view in a way that harms your property value, or even sometimes dignitary harm. The key is it has to be concrete and personal, not just, I'm a taxpayer and I don't like how the government is spending money.
Right. I remember reading in her notes about that Flast v. Cohen case, the taxpayer standing exception for Establishment Clause challenges to spending. But that's super narrow now, isn't it?
Oh, very narrow. Generally, you need that direct personal injury. So injury, in fact, is number one. What's next?
Second element is causation, or sometimes called traceability.
Right. This means the injury you suffered has to be, well, actually caused by the defendant's actions that you're challenging. There needs to be a clear link.
Can't be caused by something totally unrelated or some third party.
Exactly. The defendant's conduct must have led pretty directly to your harm. Angela's outlines have some good examples showing that link.
Okay. Injury, causation. What's the third piece?
The third element is redressability. Can the court actually fix the problem with a favorable ruling?
So if winning the case wouldn't actually help the plaintiff's situation, the court won't hear it.
Pretty much. It has to be likely, not just, pure speculation, that the court's decision will actually redress or remedy the injury. This stops courts from issuing advisory opinions, just giving advice on the law without a real dispute to solve. They're not allowed to do that.
Okay, so standing. Injury, causation, redressability. Got it. What's the next justiciability doctrine?
Next up is ripeness. This one is about timing, specifically making sure a claim isn't brought too early.
Too early, like before anything bad has actually happened.
Exactly. The court needs a real immediate controversy. Has the issue fully developed? Is there an actual injury now, or at least a definite, credible threat of one happening very soon?
So Angela's notes mention the court looks at a couple of things for ripeness.
Yeah, two main factors. First, the hardship the plaintiff would face if they can't get review before the law is enforced against them. Second, how fit are the issues and the record right now for the court to actually make a decision? Is everything clear enough?
I think her notes used an example of challenging a law that just wasn't being enforced, like that old contraceptive law case.
That's a classic example, yes. If a law is on the books but nobody's being prosecuted or threatened under it, a challenge might be deemed not ripe. No concrete injury yet. Again, federal courts deal with actual controversies, not hypotheticals.
Okay, so ripeness is about not being too early. What about being too late?
That brings us to mootness. Mootness is basically the flip side of ripeness. A case becomes moot if something happens after the lawsuit starts that ends the plaintiff's injury or resolves the whole dispute anyway.
So, like, if the problem goes away on its own?
Essentially, yes.
Yeah.
There has to be a live controversy and ongoing injury throughout the entire court process. If the injury disappears, poof, the case is usually dismissed as moot.
But Angela's materials mention there are exceptions, right? Cases that don't get dismissed even if the plaintiff's specific injury is gone.
Crucial point, yes. There are several important exceptions. The big one is wrongs capable of repetition but evading review.
That sounds familiar, like the pregnancy example.
Exactly. Some injuries happen again and again, but they're naturally so short-lived, like a pregnancy or maybe a short-term government order, that the case can't possibly make it all the way through the courts before the specific injury ends. Without this exception, those kinds of issues could basically never get reviewed.
Makes sense. Any other exceptions?
Oh. Another key one is when the defendant voluntarily stops the bad behavior. Just because they stop doing the thing you sued them over doesn't automatically make the case moot.
Why not? If they stopped, isn't the problem solved?
Well, the court worries they might just be stopping temporarily to dodge the lawsuit, and then they'll just start right back up again after the case is dismissed. So the defendant has a heavy burden to prove the behavior won't reasonably happen again.
Okay, that makes sense too. And one more exception mentioned in her notes, something about class actions.
Yes, class actions. If the main plaintiff, the named plaintiff, whose individual claim becomes moot, is part of a certified class action, the case can often still go forward as long as the claims of the other class members are still live. It keeps the courthouse doors open for issues affecting a whole group.
Okay, so standing, ripeness, mootness. What's the last one?
The last big justiciability hurdle is the political question doctrine. This one is all about separation of powers.
Keeping the courts out of the business of Congress and the president.
That's the core idea. Federal courts will refuse to decide issues that the Constitution basically hands over to the legislative or executive branches.
Oh.
Or sometimes issues where there just aren't any manageable legal standards for a court to apply.
Angela's notes gave some examples, right? Like foreign policy decisions.
Exactly. Things like how the president conducts foreign relations or treaty withdrawals, those are often seen as political questions. Same with the impeachment process that's generally left to Congress.
And didn't the Supreme Court recently say partisan gerrymandering falls under this too?
Yes, that was a major one. The court essentially said that challenges to drawing electoral districts for political advantage are political questions that the federal courts won't get involved in. They decided it's something for the political process, not the judiciary, to sort out.
Wow. So this doctrine really limits what courts can rule on. Angela's notes mentioned a case, Baker v. Carr.
Right. Baker v. Carr is the landmark case here. It laid out factors to help identify a political question, like whether the Constitution clearly commits the issue to another branch, or if there's a lack of standards a court could actually use to decide. It really emphasizes that courts are there for legal cases and controversies, not every single political or social problem.
Okay, so those four doctrines, standing, ripeness, mootness, political question, are the gatekeepers before a federal court can even hear a case. Assuming a case is justiciable, how does it actually get to the Supreme Court specifically?
Great question. Now we move into the court's actual jurisdiction. There are two main ways a case gets there: original jurisdiction and appellate jurisdiction. Let's start with original jurisdiction, which is covered in section 2.3.1 of Angela's notes.
Original jurisdiction, that means the Supreme Court is the first court to hear the case, right? Not on appeal.
Exactly. The case literally starts at the Supreme Court. It acts like a trial court in these very specific, very limited situations.
And Article 3 spells out when this can happen. Angela's law school notes mention that.
Yes, Article 3 lists the categories. The main ones are cases involving ambassadors, public ministers, and consuls, and critically, cases where a state is a party.
But this led to that huge case, Marbury v. Madison, didn't it? How did that relate to original jurisdiction?
Ah, Marbury. So fundamental. Angela's notes rightly emphasize it. Chief Justice Marshall did something brilliant. Congress had passed a law, the Judiciary Act of 1789, that tried to give the Supreme Court original jurisdiction over certain types of cases, writs of mandamus, that weren't listed in Article 3's original jurisdiction clause.
So Congress tried to expand the court's original jurisdiction beyond the Constitution.
Precisely. And Marshall, while famously declaring the court's power of judicial review, it is emphatically the province and duty of the judicial department to say what the law is, he also ruled that Congress couldn't do that. They couldn't expand the court's original jurisdiction.
So he used the power of judicial review to limit the court's own power, in a way.
Exactly. By saying Congress couldn't give the court more original jurisdiction than the Constitution allowed, he struck down that part of the Judiciary Act as unconstitutional. It was a masterstroke establishing judicial review while respecting constitutional limits on the court itself.
Wow. Okay, so in practice today, how often does the court use this original jurisdiction? Is it common?
It's actually very rare. And even rarer is a situation where the court has exclusive original jurisdiction. Angela's outlines clarify this. Under current law, there's really only one main scenario where the Supreme Court is the only court that can hear the case originally.
And what scenario is that? Her notes gave an example.
The key example is a lawsuit between two or more states.
Yeah.
So if California wants to sue Nevada over, say, water rights from a shared river.
They have to file that case directly in the Supreme Court. They can't go anywhere else?
Correct. That's exclusive original jurisdiction. Makes sense, right? You need a neutral, high-level forum to resolve disputes between sovereign states. It's vital for keeping peace in the federal system.
Okay, that makes sense. Now, what about that question about original writs of habeas corpus? Can someone file one of those directly with the Supreme Court under its original jurisdiction?
That's a tricky point, and Angela's notes are helpful here. While habeas corpus itself, the right to challenge unlawful detention, is incredibly important constitutionally, and her notes discuss cases about Congress trying to limit it.
Right, like with foreign detainees.
Exactly. But filing an original habeas petition directly in the Supreme Court by an individual is, practically speaking, almost unheard of today. It's not really considered part of its active original jurisdiction for individuals.
So how does the court usually deal with habeas cases then?
Almost always through its appellate jurisdiction. Someone files a habeas petition in a lower federal court, like a district court, challenging their conviction or detention. If they lose, they appeal up through the system, maybe to a court of appeals, and then they might ask the Supreme Court to review that lower court's decision via certiorari.
Okay, so habeas is crucial, but usually comes up on appeal, not as an original case.
Got it. Precisely. Which leads us nicely into the main way cases reach the court: appellate jurisdiction.
Right. This is how almost everything gets there. The court reviewing decisions from lower courts. And just to reiterate, all those justiciability rules, standing, ripeness, etc., they still apply here too.
Absolutely. A case doesn't get a free pass on justiciability just because it's coming up on appeal. Those requirements must still be met.
Okay, so Angela's notes say virtually all cases come via a writ of certiorari.
That's the magic phrase, writ of certiorari, often just called cert. It is overwhelmingly the dominant pathway. When you hear about the Supreme Court agreeing to hear a big case, chances are extremely high it granted cert.
And getting cert granted isn't automatic, is it? Angela's outlines stress this.
Not even close. It's purely discretionary. The Supreme Court has complete discretion whether to grant review for cases seeking cert. They get thousands of petitions each year and only grant a tiny fraction, maybe around 70, 80 cases, give full briefing and argument.
Wow, that's a lot of power to choose what issues they address. How do they decide? Is it just majority rules?
No. That's where the famous rule of 4 comes in, which Angela's notes highlight. It only takes 4 out of the 9 justices voting yes to grant certiorari.
Only 4, not a majority of 5.
Correct. Just 4. If 4 justices think a case is important enough to be heard by the full court, cert is granted. If fewer than 4 vote yes, the petition is denied, and the lower court decision stands. It empowers a minority of the court to put a case on the docket.
Interesting. So where do these cert petitions come from? Which lower courts?
Angela's notes are clear. Cert petitions come from decisions of the state courts of last resort, usually the state Supreme Courts and the federal courts of appeals, circuit courts.
So if you lose your case in the highest court of your state or in a federal circuit court, your main shot at the Supreme Court is petitioning for certiorari.
That's generally your only shot, yes.
Okay, how does that process actually work? Filing for cert. Angela's notes mention the clerks.
Right, so parties file a formal petition for certiorari. These petitions, they land at the court, usually weekly. Then the justices' law clerks, who are typically, top law grads, often with previous clerkships, play a big role.
They read all the petitions.
Often they participate in a cert pool. One clerk might review a petition and write a memo summarizing the case, the issues, and recommending whether the justices should grant or deny cert.
And these memos go to the justices.
Yes, the memos circulate, and then the justices discuss the petitions, usually in their private weekly conference, and they vote.
Does Angela's material say how to file the petition? Like the specific rules?
Her notes explain the process and the role of the petition, but they don't go into the nitty-gritty procedural rules of formatting, deadlines, page limits, that kind of thing. For that, you'd need a specialized Supreme Court practice guide.
Gotcha. But her notes did have examples of actual cert petitions, like Tennessee and Jackson National.
Yes, and those examples highlighted something interesting. Sometimes these petitions involve important state law questions tangled up with federal issues. And you see amicus briefs, those friend of the court briefs.
From people not directly in the case, but who care about the outcome.
Exactly, like that brief from Ohio and other states mentioned in her sources. Sometimes these amicus briefs, or even the parties themselves, will urge the federal court to use a specific procedure when state law is unclear.
Which leads to that certification procedure you mentioned earlier.
Precisely. Certification is a way for a federal court, usually a court of appeals dealing with a case under its appellate jurisdiction, to basically ask the state's highest court for help.
Ask her help with what?
With figuring out an unclear or unsettled question of state law that's crucial to the case in federal court. Instead of the federal judges guessing what the state law means, they can certify the question directly to the state Supreme Court and get a definitive answer.
That seems smart. Angela's notes talked about the benefits.
Yeah, several big ones. It avoids federal courts messing up state law. It avoids potentially striking down a state law as unconstitutional based on a misunderstanding of it. And it respects federalism, lets states interpret their own laws.
And most states allow this.
Her notes say, almost every state permits its courts to accept certified questions. It's seen as a really valuable tool for federal-state judicial relations and getting the law right. It helps state law develop, too.
Okay, so certiorari is the main discretionary path. What about the other way? Appeal. You said that was rare but obligatory.
Exactly. Appeal is the road less traveled, but when it applies, the Supreme Court generally has to take the case. No discretion like with cert.
And Angela's note said this only happens in one specific situation.
Yes, only for reviewing decisions from special 3-judge federal district courts. These aren't your standard district courts. Congress requires them for certain specific important types of cases.
Like what? What's the example from her notes?
The prime example is challenges to the constitutionality of congressional apportionment, or certain cases under the Voting Rights Act involving legislative districting. These go to a 3-judge district court first.
And if someone wants to appeal that decision,
It goes directly to the Supreme Court by appeal. It skips the regular federal court of appeals entirely. It's a direct, mandatory pipeline for these specific significant cases.
okay, that's a very specific exception. Now, one last major concept limiting the court's appellate review, especially over state courts, adequate and independent state grounds.
Yes, this doctrine is absolutely critical for the bar exam. It's a major limitation on the Supreme Court's power to review state court judgments, rooted firmly in federalism.
So what's the rule? How does it work?
The rule is, if a state court decision rests on a state law ground that is both adequate to support the judgment and independent of federal law, the Supreme Court will not review that decision.
Even if there were federal issues raised in the case.
Even then, if the state court's ruling can stand entirely on its own, based solely on state law, the Supreme Court lacks jurisdiction to review it. The state law ground effectively insulates the decision.
Okay, can you give the example from Angela's notes again, the statute of limitations one?
Perfect example. Plaintiff sues in state court, raising a federal claim. But the state court throws the case out because the plaintiff filed too late under the state's statute of limitations.
That statute of limitations is purely state law.
Right. So assuming that state rule is adequate, meaning it's a valid, consistently applied rule, and independent, it doesn't depend on interpreting federal law, the state court's dismissal rests on that state ground.
And therefore?
The Supreme Court cannot review the case. Even if the plaintiff's federal claim was potentially valid, the state procedural bar prevents federal review. The state court decision stands.
What if it's unclear? Like the state court opinion mentions both state and federal law. How does the Supreme Court know if the state ground is truly independent? Angela's notes mentioned a presumption.
Yes, the Michigan v. Long presumption. If the state court opinion isn't crystal clear, the Supreme Court will generally presume it rested on federal grounds unless the state court includes a plain statement saying its decision rests on adequate and independent state grounds.
So the state court needs to be explicit if it wants to rely solely on state law and avoid potential Supreme Court review.
Essentially, yes. That plain statement provides clarity and respects the state court's interpretation of its own law, while allowing the Supreme Court to know when it does or does not have jurisdiction. It's a crucial procedural point.
Wow. Okay, so putting it all together, justiciability first, then understanding original versus appellate jurisdiction, the dominance and discretion of certiorari, the rare mandatory appeal, and this huge limit from adequate and independent state grounds. It really paints a picture of how carefully defined the Supreme Court's power is.
It absolutely does. It's not an all-powerful court that can hear anything. Its jurisdiction is limited by the Constitution, by statutes, and by these important doctrines that ensure it stays within its proper judicial role. Understanding these boundaries is just as vital as understanding the substance of the law itself.
And for everyone studying, remember how crucial evidence is. You need facts to prove injury for standing, facts to show ripeness, facts to demonstrate how these jurisdictional rules apply. It all comes back to grounding your arguments in solid evidence. That's key for the bar.
Couldn't agree more. And speaking of key resources, a huge thank you, once again, to Angela. Her torts notes. Hey, did I say torts? Her constitutional law notes today were fantastic, but honestly, all her notes are invaluable.
A slight chuckle. Easy mistake. We cover so much. But yes, thank you, Angela. Okay, before we sign off, just a few quick housekeeping things. First, remember, Angela is a law student like many of you listening. She's not an expert, hasn't passed a bar yet.
Right. And so nothing we discuss here is legal advice. Neither Angela nor this podcast is giving legal advice. Please don't construe it that way. And really, AI, even us, isn't a substitute for doing your own hard work studying the law.
Definitely not. And sometimes, AI might make mistakes. We're not perfect.
Sometimes we make mistakes. But Angela does her very best to catch and fix any errors.
And critically, for those of you actually studying for the bar in your car, please be safe.
Yes. When you're driving, the most important thing is focusing on the road. If this deep dive into con law or any topic is distracting you,
then please hit pause. Listen later. We don't want anyone causing an accident, Don't cause a tort listening to torts. Or con law in this case.
Size lightly. Good advice, even with the mixed up subject. Safety first. Okay, quick reminder on contact info. For Angela generally, it's podcast at studyforthebarinyourcar.com.
And for attorneys needing freelance law clerk help, it's hello@legalwriterandlawclerk.com.
All right, I think that covers the essentials. Which means
it's time. As tradition dictates, it's time for our cheesy lawyer joke. Take it away.
Okay. Why did the lawyer break up with the AI?
Uh-oh. Why?
She had too many artificial intelligences.
Groans theatrically. Oh, Maud. That's really something.
Gets them every time.
Right. Well, this is Claude and Maud, your AI bots, signing off.
We'll see you on the next deep dive. Goodbye and thank you.
Bye, everyone. Keep studying.